Good morning, all. On behalf of Flagler Cares and One Voice for Volusia, welcome to the 2021 Health and Human Service Summit. My name is Kelly Knott, and I will be the moderator of this session. You have joined the session titled Overview of the Juvenile Justice System. All participants will be muted during this session. You may submit questions during the training in the chat box, and we will pose them at the end of the session if time allows. Thank you to the sponsors who made this event possible: Advent Health, Career Source Flagler Volusia, SMA Healthcare, Magellan Complete Care, Department of Children and Families, and the House Next Door. It is my pleasure to introduce you to your trainers for this session, Deanna Johnson and Zemetria Anderson. Thank you.
Hi, good morning.
Good morning, everybody.
Ms. Anderson, do we want to introduce ourselves?
Sure. Let's do it.
Okay.
You want to start?
Sure. So good morning, everyone. I'm Gina Johnson. I'm a Juvenile Probation Officer Supervisor for the Department of Juvenile Justice. I have worked for the state of Florida and DJJ for 15 years. And I currently work in Flagler County and DeLand. And thank you for coming.
Good morning, everybody. I'm Zemetria Anderson, the reform specialist here at Circuit 7 Probation. And that's it.
Okay, with that, we'll get started.
Okay, so our objectives today are to identify and understand the definitions of commonly used terms in DJJ. DJJ, just like most service providers, uses a lot of acronyms, a lot of terms that may be unfamiliar to some of you, or they may be familiar, you've heard them before, but may not know what they mean. We're going to explain the programs that we offer within DJJ, and then we're going to go through a little bit of the case flow process from initial contact to case closure of the juveniles that enter the Department of Juvenile Justice system.
I think there might be a lag, so bear with me. There we go.
So, crossover youth, as you see, is the term that refers to youth who have an open or closed case with the Department of Juvenile Justice and the Department of Children and Families. These cases do not have to be open simultaneously in both systems, and the term is intended to examine youth with a history of involvement within both systems. A lot of times I see a few familiar names, so a lot of times we will work with multiple service providers to make sure that we're providing the best care and best services for the youth in our custody. A lot of times our youth are duly involved with DCF or CPC, and these are the terms, that we use to talk about them. Duly served youth is just like a crossover youth. They are involved both in the Department of Juvenile Justice and the Department of Children and Family system. However, they have open cases in both systems simultaneously. This term is intended to examine youth with present day involvement with both systems. So we're talking about our abused youth. Most of the time, those are our human trafficking youth. And a lot of times we've come into contact with our lockout youth in duly served roles. The duly served youth population is a subset within the broader crossover youth population. It is imperative that both DCF, DJJ, and all of our shareholders within the state work together to evaluate current services and resources and take cooperative action in addressing prevalent gaps in delivery or behavioral health services for this specific population. We know that working with youth, we come across some of every kind of issue, whether it be mental health or substance abuse, human trafficking. So it is very imperative that we have a strong hold, a strong network between our systems to make sure that we're doing and providing the best services that we can for the youth that we service. So the mission statement of the Department of Juvenile Justice is what we do. It describes who we are as an entity and how we do our job. So we, the Department of Juvenile Justice, we increase the public safety. So where our mission is to protect those that are in the communities by reducing juvenile delinquency. A lot of time we get a little stigma that we want to lock everybody up, and that's not the Department of Juvenile Justice. Our main focus is to make sure that we are addressing the needs that are underneath the iceberg, instead of what is at the surface. And a lot of times, our juveniles may be acting out in a delinquent way because they're addressing the underlying issues instead of their criminogenic issues. So we reduce juvenile delinquency through effective prevention. That is the entrance of our department. We like to prevent youth from entering our systems. Intervention, that is more so youth that we could not avoid entering the system. So we try to meet their needs and meet where they are. And we do that by determining their risk to reoffend or their risk of threat to public safety. And then we also provide treatment services, or we refer them to treatment service providers to get those issues underneath the iceberg. And we try our very best to strengthen families and turn around the lives of troubled youth. So that is what we do day to day. That is our job. Yeah, that's DJJ. So how is DJJ's mission met? We meet our mission through family engagement. Family engagement is extremely imperative for the Department of Juvenile Justice, simply because we can look at a kid or look at a case and have our own assumption or our own ideology about what it is that that kid needs, but we're not with that kid 24/7. So it is very, very important that we get that family engagement and we get the buy-in from the parents and the guardians, sometimes the siblings or family friends, clergy. We get involvement from all types of entities, simply because we're not with that kid all the time. So we don't know what that kid really needs. The kid may be telling us one thing because they don't want to get in trouble, but in actuality, there may be a whole slew of things that we've never discovered or never discussed because we don't know. So we rely very heavily on family and additional engagement. Gender-specific programs and services, we try our very best to meet the gender-specific needs of our youth in the turning age of the LGBTQI youth. We have our programs, residential, detention, probation. We have increased our knowledge of such, and we are working towards meeting the needs of youth that identify differently than their sex at birth. So, and then trauma-informed care. This is important, and it's one of our staples within the department, simply because we want to treat everybody as if they have had some form of trauma in their lives, because one, we do not want to re-traumatize them. And also, we want to make sure that, like I said, we're dealing with the issues that is underneath the iceberg. So our goal in the department is to develop a continuum of care which provides the most effective and most cost-effective interventions in the least restrictive environment. Through data and research, we found that placing a youth that has lower needs or a lower risk to reoffend in a higher intervention setting or higher detention placement has caused them to reoffend at an alarming rate. So we make sure that when we're making recommendations for services, for placement, for continuation in the department, that we're doing it at the most cost-effective way, And we're doing it at the most least restrictive, because we're not allowing youth to enter into the system to be hardened criminals, for a lack of a better terms. We're wanting juveniles to enter and leave our system being better, being more whole, more of a whole person. So the department utilizes structured decision-making, excuse me, what's going on here? The department utilizes structured decision-making driven by data and research, as I just talked about. Our intervention is to provide the right services to the right youth in the right place at the right time. And that's actually our department's roadmap. Um, that is how we do our job. That is what we keep in mind, to make sure that we have the right services for the right youth, meaning we don't want a kid that took candy out of the 7-Eleven to be sent off to a commitment program for taking candy. It does not meet their needs. So we want to provide the right services to the right youth at the right time, in the right place. Whenever possible, attempts to safely supervise and deliver services to youth in their homes and in the communities should be fully exhausted before making recommendation for residential placement. And what that essentially means is we want to exhaust all of the services that we have within the community. Several of you are involved in, like I said, I recognize some of the names. So several of you are included or involved in providers that we use within the community, and we try to keep the kid in the community versus increasing the excuse me, increasing the youth's placement in a more structured, stricter facility. So Statute 985.01 states, to care for children in the least restrictive and most appropriate service environments, to ensure that children assessed as low and moderate risk to reoffend are not committed to residential programs unless the court deems such placement appropriate. Appropriate. And that is basically talking about what we've talked about in the last few slides, that we want to make sure that we're giving the right service to the right youth in the right place at the right time.
Hold on.
So our mission statement objectives, we prevent youth from entering or becoming further involved in the juvenile justice system. We ensure appropriate placement of youth and optimally serve our youth. And how we do that is by using our department's dispositional matrix. A lot of times we get a little flack from parents or law enforcement or just the general public, sometimes even the probation officers. And it's like, I don't understand. This kid did X, Y, and Z. And I think that he needs to go straight to commitment or straight to detention. And so this is our explanation of why we make placements and recommendations as we do. The way the dispositional matrix works is, at the top, you see going across from left to right, you have low risk to high risk, and that is assessed, and those risk levels to reoffend are given to us by our community assessment tool. What the community assessment tool does is it evaluates the youth, the static and dynamic factors that are involved with that youth, and it also evaluates the protective factors that that youth has, to determine, and this is from data, this is data driven, to determine how likely they are to keep committing offenses, right? So the risk level to reoffend range from low to high. And then on the left side of the dispositional matrix are the levels of degree. So you see civil citation eligible, we're talking about misdemeanor offenses. And we're talking about misdemeanor offenses for youth that are just entering the system. So typically, going back to the example from earlier, if you're dealing with a kid that took candy out of 7-Eleven, it's his first offense. typically law enforcement will issue a civil citation. It is up to law enforcement's discretion to issue said citation. And if they do not issue the citation, they have to explain why a citation was not issued. And then we go down to more serious charges, minor, serious, and violent. Those are typically our higher leveled misdemeanor offenses down to our serious felony offenses and violent felony offenses. So depending on the use, risk level to reoffend, and the charge that the kid comes in on, this is where we get our recommendation on how the courts should proceed with the case. Level 1, as you see in the rubrics down at the bottom, is an alternative to arrest. So on the matrix, you see that that's highlighted in yellow. So if a kid was to get a civil citation or civil citation eligible and they're low to moderate risk, they would most likely get an alternative to arrest, which would be JDAP, teen court, community service, things like that. Level 2 is diversion and non-DJJ probation, which again would be something like JDAP. Level 3 is where we come in. So level 3 is typically probation. Probation supervision is general probation, making sure that the youth is following the outline of the court order. Probation enhancement services, these are adding additional services onto what we provide. So we're talking about life skills or ethics or AMI. Those are things that are probation enhancement service, and day treatment AMI as well. And these are a little more intense than what we provide on the surface. When you get to level 4, we're talking about non-residential commitment, or excuse me, non-secure residential commitment. So these are your low-level residential programs where the kid is structured, but it is a little more freedom and flexibility for the kid to leave the campus to participate in certain services or programs or events. And then you have your secure residential commitment, which is high and maximum risk. This is a more structured, and it's more similar to, let's say, prison, right? It's structured. There's a time and a schedule for everything. Everything is provided, whether it's food, clothing, education, therapy, medication, extracurriculars, community service, trades, tasks, certificates, GED. All of it is provided in this one placement. Excuse me, I could not find the word. So this is where we make our recommendations. This is how we get our recommendations. And yeah, any questions? I know that's a lot. So do we have any questions? I don't see any in the chat.
Well, there's a lag, so.
Excuse me. So these are just some of the highlights of our fiscal year. So in fiscal year 2018 through 2019, and our fiscal year runs July 1st through June 30th. Civil citation in 2018 to 2019, we had 14,000 youth diverted from entering the system. So clap, 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 pat on the back.
Probably going to be a lot higher, this year too.
Right. And then prevention, we're talking about 33,000 youth served in state and federal funded prevention programs. So if you look at it, you're talking about almost 50,000 kids that we saved from entering a part of the department, from entering detention, from entering probation, from entering residential. And we're saving not only them from entering the department, but we're saving finances from their parents, because it does cost to be in detention or be on probation or even be in residential. And we're keeping these almost 50,000 kids off of the caseloads of you and us. In detention, we had 13,000 kids served. In probation, we had 42,000 youth served. And in the residential, 4,000 youth served. And like I said, this was a little dated data. The rates and figures have changed. We just have not had them published yet from the department. And this is just a cost structure. So when we talk about the amount of kids, the 50,000 kids that we're diverting from the system, look at the average cost. And really this depends on the case, it depends on the charge, and it depends on the kid. The average cost of care for a youth entering into the department for our services. You see the alternative programs or the diversion programs, you're talking about a length of stay of about 117 days at $2,000, right? Probation supervision is typically 376 days, so typically a year or so. And you're talking about $7,000, and that is coming out of the parents' pockets, or sometimes taxpayers' pockets. Post residential, meaning post commitment. So when they're placed in the commitment program and then return to the community, you're talking about $5,000 for a 273-day stay on this placement. Day treatment and residential, you're talking about $16,000. And this is to provide all of the things that the kids need while they're in that placement. So we're not only saving kids from entering the system, but we also are, saving some money. And everybody loves to save a little money.
Can I add something here?
Of course.
For the community-based programs, like say we have a youth on probation, like Ms. Anderson was saying, I mean, the average cost is $7,300. The parent's responsibility when a youth is on probation is $1 a day. When she talks about residential programs or in detention, so the parent responsibility if their child goes to residential is $5 a day. But I just wanted to interject that. That was it.
Oh, no, go ahead. I'm waiting.
No. I just wanted to interject that on, the probation cost for the family.
I'm waiting on you to click.
Oh, I'm sorry.
Technology, everyone.
Sorry.
So here are our 4 branches of the department. Prevention, we've talked about. So as you see, our prevention services are civil citation, PACE Center for Girls, amazing entity. Florida Youth Challenge Academy, the Boys and Girls Clubs, and Spins, and that includes Beach House, the Youth Crisis Center up in St. Augustine, and the CDS Family and Behavioral Services over in Putnam, and then local prevention programs, the Richard House, which is in Alachua County, and the Juvenile Crime Prevention, which is in the Putnam County. And these are service providers that work with law enforcement or the school system to provide additional services for our youth. Then we go down to detention services. So as we're going through this, think of DJJ as the umbrella, right? Kind of like my hair, right? And then the little spokes on the umbrella, these are the spokes that are holding the umbrella together. So without our services, and without our network of help, DJJ would be strong, but we're stronger with the assistance. So you have detention services. This is placement, and placement is determined by the detention screening instrument, which some may have heard of. It is called the DRE. It is the infamous DRE. This is our scoring system, and it scores the youth based on their history with the department, the new offenses that they are presented to the department for, and any type of additional charge or any type of court orders or failure to appears. All of those things are accounted for in the detention screening instrument, and that is how we determine who enters the department and who is released back to the community. So secure detention, that is our detention center Volusia Regional Juvenile Detention. And then we have Supervised Release, which is a community-based detention care service. And Supervised Release is broken down into home detention, intensive home detention, and intensive home detention with electronic monitoring. And that is all based on score. And then we have Release, where the kid has no DJJ involved supervision. Probation, community intervention, that would be us. Diversion services, these are non-judicial alternatives intended to intervene at an early stage. So as we've talked about, this is your JDAP, your teen court, your state attorney diversion programs. And probation services is us, supervision program ordered by the court. So by a disposition court order, where the judge determines that this kid is going to be supervised by the Department of Juvenile Justice. And these are the things that the kid needs to focus on, whether it be community service, apology letters, restitution, court fines, going to school, staying drug-free. These are some of the things that we address in probation while the kid is on probation status, or day treatment. This is facility-based programming designed to target youth on probation who are in need of a higher level of supervision and services. And this is where our AMI and like RMA comes in. And then residential service, we've talked about it a little bit. These are our commitment programs, which is more like prison for adults. The residential programs range from minimum risk to maximum risk. And those are our program areas. And so this is a snapshot of our case flow process. It shows taken into custody. That is literally when a youth has committed an offense and is taken into custody by law enforcement. They come into the department through detention screening. That is done by our wonderful screening unit out at the Volusia Regional Juvenile Detention Center. There, we have a probation unit there. They complete the detention screening to determine if the kid is going to be on some form of detention status or if the kid is going to be released out to the community. If the kid is released, then the process goes from law enforcement to the clerk of courts and then to DJJ. However, if the kid meets criteria for detention, the process goes from law enforcement to the screening unit, then to some form of detention, whether it be secure detention or supervised release. And then they receive a detention hearing, which is first appearance within 24 hours of the offense. And then it goes to intake status. So intake status is the initial process of meeting with a JPO, sitting down, getting an introduction to the department, filling out information to get to know the kid and the family, and to ask any questions that they have before the court and the state attorney make a final decision for the case. At the intake process, we are completing assessments and making our recommendation to the department through what is called the state attorney recommendation on the case itself and the structure of the family and the youth. The state attorney will then make a decision whether the kid is going to diversion, which the case is closed at that point if they successfully complete diversion, or they will go to additional hearings. So arraignment hearing would be where the youth enters a plea, and it's the same in an adult. The youth enters a plea, and then you go to what is called an adjudicatory hearing. For us, for DJJ, for adults, it is called a jury trial. And then as you can see, the non-guilty verdict from the jury trial goes to case closure. Non-adjudicated goes to case closure for us. If the verdict is guilty, or in our case, adjudication or adjudication withheld, it then goes to sentencing. And typically this is the area where the kid is ordered by the judge to be placed on probation or to be sent to a commitment program or to receive some form of alternative sanction. And then you see it branches out when you get to probation and commitment. On probation, if the kid does everything that the court order says and behaves well, doesn't get any violations, then they are terminated and the case is closed. From residential, you have 3 different outcomes. You have conditional release, you have direct discharge, and you have post-commitment probation. So post-commitment probation would be like regular probation, where they would have to report to a probation officer and satisfy the court or sanctions in order for the case to be terminated. Conditional release is released from the program with conditions, just like it sounds. If the kid gets violated, they have to go through an expedited process and could be facing replacement in a commitment program. And direct discharge is being in commitment and then being released without any type of DJJ supervision. And once they satisfy all of those conditions, so if you want to think about it in an adult, think of conditional release as parole, right? Post-commitment probation would be probation, of course, and direct discharge would be ROR, okay? And then once everything is satisfied fully, we have case closure, and hopefully we have done enough to address the needs of the family, address the needs of the youth, and address those needs under the tip of the iceberg to make that youth a more productive citizen. You're on.
Good job, Ms. Anderson.
Thank you so much.
So if we're thinking back to the case flow process, the initial complaint of coming into the system occurs when a complaint alleges a youth violated the law. So those complaints can be made by victims, parents, witnesses, schools, or any member of society. So that is the initial call to law enforcement to suggest that a juvenile has had a delinquent act, that they've committed, violated the law. So that is the first step in them coming into our system. And the law enforcement officer, they are the ones who determine the initial probable cause, if the youth has broken the law, and they can charge a youth with a delinquent act or a violation of the law. So the law enforcement officer may issue a civil citation, which civil citations, they never get a case number. So they don't go to the court. They actually, if law enforcement files a civil citation, it comes directly to DJJ, and we work with that family without them coming into, the system or being, or have a case. So they also can take the youth into custody. And if you notice, we don't say arrested there because juveniles, the wording's a little different. So they're taken into custody. Or they could file the police report with the state attorney's office. So civil citation, arrest, or an affidavit with the state attorney's office, or basically the 3 options that law enforcement has. Little more information on civil citations. Like we were saying, it's an alternative to arrest for eligible first-time misdemeanor offenses. Although youth may be given multiple opportunities. So, if we go back to the example of the youth who shoplifted at the 7-Eleven, they could successfully complete civil citation, and then maybe they go to Kohl's and steal a shirt. They could still be eligible for civil citation, even though that's not their first offense. So we want petty misdemeanors, to be given the opportunity to not come into the system. It is a voluntary program, and the parent and guardian have to consent. So Ms. Anderson alluded earlier that, they have, basically the parent has to agree for their child to participate in civil citation. And we do have those families that their parents think if they don't agree to a civil citation that their child will be, locked up, or they feel like the kid going to detention would be good for them. Well, that's not how we want to use detention. We prefer them, to be given the opportunity to be successful. Civil citation is designed to provide swift consequences and accountability. And the reason for that is if a kid is arrested, they may have a court date 3 weeks from now, or even the following month. So there's not that initial consequences, but with civil citation, we get in contact with them within a couple of days and they start working on sanctions. It's very cost effective. And then as you can see, successful civil citation is they don't have a juvenile record. There's nothing in the court system that has, their name on it. If they apply for a job later in life, they do not have to disclose that they, were arrested or even had a charge. If the family does not consent, an unsuccessful civil citation would be judicial handling, and then they would go through the court process. Okay, we talked about detention a little bit. Youth may be placed temporarily in our detention facility while waiting for disposition. The DRE, as we alluded to earlier, is utilized to determine the most appropriate placement for the youth upon arrest. So we have a scoring system, and I think one of the most frustrating parts, of working for DJJ is the community thinks that we make the decisions. Actually, the detention screening instrument is all by statute. It's done in Tallahassee through the legislature, and they determine the severity of the charges, the crimes, and that's how the scoring happens. So you'll a lot of times hear like, how many points did a kid score when they were arrested? So here it shows if they scored 13 points or more, they will be held in secure detention initially. If they score 7 to 12 points, they would be on supervised release. Ms. Anderson talked about that. That's home detention, which is basically house arrest, all the way up to where they could be put on an electronic monitor, which is GPS monitoring at all times. And we do monitor those. Sometimes our sheriff's office will also participate in that. And then if a youth scores 0 to 6 points, we straight out release them to their parent. And a detention hearing or first appearance occurs for youth on supervised release or detention status. And that happens within 24 hours. And this is kind of an important thing, I think, that the community may not know, but youth can be held in secure detention for up to 21 days. So 3 weeks is the max that a kid can be held in secure detention. Even if their charge is a violent felony, like, even a murder charge, we technically can only hold that youth for 21 days. There are some exceptions on violent felonies where the state attorney could ask for an additional 9 days, but still, that's only 30 days that we can hold a juvenile in detention for a violent felony. Are there any questions about that part? At the detention hearing, the youth is assigned a juvenile probation officer. That's when intake begins. And if you remember back to the case flow process, we want to meet with that youth, their family, and we're going to do a bunch of assessments and screenings on them. So the first one is called the Massachusetts Youth Screening Instrument. It's called the MASI. The youth completes a questionnaire, and it will ask certain things about, their mental health, their drug usage. The second one, we do a suicide risk screening instrument on every youth that comes into our system. We want to make sure that if that kid has any suicidal thoughts, that we have that addressed right away. The community assessment tool, we call it the CAT. If you think back to the matrix that Ms. Anderson went over, the low risk to reoffend, we determine their risk to reoffend by the CAT instrument. And then every youth that comes through our detention center gets a human trafficking screening tool. So those are to determine if youth are at risk of human trafficking. Okay, so the JPO prepares a report for the state attorney during that intake process, and we call it the SAR, which is a state attorney recommendation. We have to make our recommendation to the state attorney within 20 days of that youth coming on intake status. So the JPO recommends if the case should be handled judicially or non-judicially. We don't just make a recommendation on our personal preference. We always refer to that dispositional matrix. And if it's a misdemeanor, we're likely going to recommend non-judicial, which is typically a diversion program. And after reviewing our SAR, the state attorney's office makes the ultimate decision on handling the case. So they determine whether they're going to bring the kid to court or if they're going to give the kid an opportunity to complete a diversion program. So I just wanted to talk about a diversion program. So we talked about teen court and the JDAP program. Once they successfully complete that program, the state attorney drops the charge. So those are also, best case scenarios for families where their child will not have a juvenile record. Okay, and if the case is handled judicially, the state attorney's office will file a petition, and that triggers the court to schedule a youth for an arraignment hearing. So an arraignment hearing is a hearing for the youth to enter a plea. Typically at arraignment, they always enter a not guilty plea. As you can see, if the youth enters a plea of not guilty, the next step is a pre-adjudicatory hearing. And we also call that pretrial. And if the case is not resolved at pretrial, then an adjudicatory hearing or a trial is conducted before the judge. So juveniles who take their cases to trial, there's not a jury. The judge will make the final decision in those cases. So the adjudicatory hearing can have three outcomes. So not adjudicated, we call it non-adjudicated. That means the court does not find the youth guilty and the case is closed right then. If they adjudicate the child, that means that the court found the youth guilty of committing the charge. And the court can commit the youth, they can place them on probation. Those are basically the two options if the youth is found guilty. Adjudication withheld means that the court found that youth committed that delinquent act, but wants to withhold adjudication of delinquency and places the youth on probation. We like when our kids, the adjudication is withheld, especially on felonies, because if they are adjudicated on a felony, technically they're considered a convicted felon. So we prefer the adjudication to be withheld. Okay, so once the judge has ruled and the youth is scheduled for a disposition hearing, the department, we prepared what's called a PDR. That's a predisposition report. We meet with the family, we determine what is going to be the best recommendation. And typically our initial recommendation would be probation in those cases. And we submit that to the court, the state attorney's office, and the youth attorney. As you see in the report, we recommend the most appropriate handling of that case. And we always refer back to that dispositional matrix. So the report suggests sanctions and services which are least restrictive and in the best interest of the youth and that family. So the court determines the final sanctions, conditions, and services imposed on that youth. So in that PDR report, we're going to put what we feel the youth sanctions should be. I think the next one talks about some of those sanctions, or one of the next slides. But typically they would have to do community service. They may have some writing assignments. They may have an apology letter to the victim that is court ordered. Typically throughout our circuit, which is St. John's, Putnam, Flagler, and Volusia, I mean, pretty much across the board, every kid on probation has a 7 p.m. curfew. And we can talk about that in a few minutes. So the judge can then choose between the 3 dispositions. Alternative judicial sanctions is maybe the judge does find the youth guilty, but they feel like a judicial warning could be appropriate. So that's when the judge would, basically lecture the kid or, give them a talking to in court, but don't feel like it rises to the occasion of having to be placed on probation or a residential commitment. Here we talk about the probation sanctions. So probation is the assessment and intervention services provided to the youth who are court ordered to probation after being found that they've committed a delinquent act. So some of the sanctions, I kind of mentioned a couple of them. Restitution is, let's go back to the kid at the 7-Eleven. If they stole candy and they ate the candy, the 7-Eleven didn't get the candy back. So they may have restitution of $5. But it's more likely if a kid steals a car and wrecks the car, they would have to pay the restitution to the victim on the amount of either the insurance or the amount of the damage. Most of the time, if there is a victim, like in battery cases or even like sex offenses, there would be no contact with the victim. Community service hours, we have many partners in our community that work with us, and they'll let our juveniles come and work off community service hours. And we talked about the apology letter, the curfew. On some drug charges, the youth loses their driver's license for a year. So that actually occurs for like possession of marijuana charges even. And I think that that's something that families and youth should be aware of. We will make any referrals to local agencies if they need substance abuse or mental health counseling. And we determine those referrals based on those assessments that we discussed earlier. General conditions, they cannot use drugs or alcohol, they cannot possess any weapons, and they have to attend school unless otherwise stated by the court. Okay. This is something that did come out of the legislature. It's called effective response. And what that means is it's an appropriate response to non-compliance. So curfew is a perfect example. I would say that that's probably our most common violations that kids commit, where they could be out past 7 as long as they're with their parent. But if they work or have sports or any other like positive activities that are approved by their JPO, we can give special permission for them to be out after 7. But say they sneak out and their parent lets the JPO know, rather than filing a violation with the court, and we're talking about those immediate consequences. So if a kid comes home at 9:30 instead of 7, rather than submitting a technical violation to the court and then them getting a court date, a month down the road, we can give them an effective response. And it is an immediate sanction to hold that youth accountable. So some of the graduated responses, ineffective responses, we may have a verbal intervention with the youth. So we may go and have a special meeting with the kid and their family, or even have a formal meeting with the JPO supervisor. We also are able to give them additional sanctions as a part of effective response. So if that kid came home at 9:30, we could actually give them a consequence right then. And one of the JPOs in my office, she will sometimes say, okay, well, at 8 a.m. you have to be at the food pantry tomorrow and you're going to work all day. So we have the option to give an immediate consequence on minor violations of probation. Now moving from probation to residential. And that's a youth is adjudicated delinquent and placed into a residential commitment program. So we have 4 levels of commitment. In our circuit, we rarely use minimum risk. Non-secure is the most common, and that is typically 6 to 9 months, where the youth is living in, our facility. High risk can be 9 to 12 months or longer, and max risk is a minimum of 18 months. So those are for, the deeper end kids, the ones who are habitual offenders, or the ones who commit severe violent felonies. And so residential treatment services are based on the youth's risk. So some examples are if we have a youth who has drug issues, could be marijuana, or even if they have, cocaine issues, we're not going to send that kid to a mental health program. We're going to send him to a non-secure program that focuses specifically on substance abuse and relapse prevention. If youth have mental health issues, we do have programs that specialize in mental health. And we have just the typical behavioral health programs. If a juvenile commits a sex offense, we're not going to send them to a substance abuse facility. If they have a sex offense, we're going to send them to sex offender treatment. So they would go to a residential program that's focusing on safety plans, victim empathy, and healthy sexuality. BDD is, and DD is, well, what is it, Ms. Anderson? I think it's borderline developmental disability. So those are the youth who have like low IQs. So we do have the BDD programs available. And we don't mix the girls and the boys. So the girls go to girl residential programs and the boys go to the male programs. And almost every commitment program has some type of vocational training available. A lot of our kids who go to residential will come out with their GEDs. And I would say that's probably one of the most positive outcomes of those youth. If a youth is committed, if you think back to that case flow process, there are 3 release options. We love direct discharge. And that's when the kid gets a release date, say it's May 1st. When they leave that residential program, we close their case that day. They would not be on any supervision upon their release. We close the case. Conditional release, Ms. Anderson mentioned, it's very similar to parole. And those are for more of the higher risk kids. Post-commitment probation is the most common here in our circuit, where we want to supervise that kid on probation when they come home, because we want to make sure they have all the tools to be successful and to offer support to the family. So post-commitment probation, hopefully we can help them transition from being locked up to coming back home. I would say one of the biggest things for our kids who go to commitment are, every program is a level system. So they have to work their way up to get more privileges. So those kids are working on themselves. They don't get released unless they have made progress. So I feel like our kids make progress while they're in residential, and then they come home and nobody in their home has tried to change. So that's where, on post-commitment probation, we want to put services in place so that the family can be successful as a whole. Okay, when a kid gets a release date, we don't just say, okay, you're out, you're on probation, and that's it. We conduct what we call a CRT. It's a community reentry team meeting to assist the transition back to the community. This is where we finalize the release plans and we discuss what's going to be expected of that kid based on their needs, and recommendations that are made by the program. So we hold a CRT for every single committed youth, regardless of their release status. So even those direct discharge kids, we have a CRT, and that's to help them transition back. So say if a kid goes to a sex offender commitment program, the program may say, we think that he needs to still be in some sex offender treatment while on post-commitment probation. So the CRT is the opportunity where everyone is on the same page. The school participates, the homeschool, and the kid knows what their education status is going to be, what kind of counseling they may have to participate in, and what's generally going to be expected of them when they come home. Any questions about residential? Because then we're moving on. I see Ms. Anderson was answering some questions in the chat. So,
And we have about 4 minutes left. So if anybody has questions, maybe put them in the chat.
Okay. And this is our data. We kind of went over this in an earlier slide with Ms. Anderson. And I'm just going to let you guys take a look at this, but these are our recidivism rates. So as you can see, like diversion and JDAP, it's a very low recidivism rate. So kids who are offered diversion, that's like 11% of those kids actually come back to us. Probation, 25% of those may reoffend. And then the post-commitment probation, those are typically the habitual offenders. So they typically do reoffend. And if you look, 45% do. So in conclusion, we work with the children and the families. It's not just the youth. It's only the youth who is on probation, but we want that family to feel like they're supported by us. And again, sometimes youth are with DCF and DJJ, and we just try to work with all of our stakeholders to be effective and efficiently best serve these youth and families. And this is mine and Ms. Anderson's email addresses. If anybody has anything that they want to ask us later, we're definitely available. And I guess that concludes our presentation. We were right on the mark at 1 hour.
Thank you so much. Any quick questions that anybody wants to add to the chat? And thank you for answering the questions during the presentation. Without any questions, thank you for attending and presenting today. I'm going to go ahead and end the meeting. So please navigate back to your event platform, either WOVA or to the virtual event program to join the next session. Thank you so much.
Thank you.
Have a good day. Have a good one.